Hello, good afternoon, and welcome to The Law. This is your legal light. It is your help law. I'm your host, Samson Lardy Anyenini. And this afternoon, we continue with exploring the subject of community sentencing. And we're asking, continuing from what we did last week, why can't Ghana have a community sentencing policy, particularly for minor offenses? Don't go anywhere, stay with us. This is The Law. It's your legal light. It's your help law.
Clause 2 of Ghana, 1992, Article 19, Clause 2C. A person charged with a criminal offence shall be presumed to be innocent until he is proved or has pleaded guilty. Constitution of Ghana, 1992, Article 19, Clause 2C. A person charged with a criminal offence shall be presumed to be innocent until he is proved or has pleaded guilty.
You're welcome back. And the Law 101, what we normally do, we will do that for you so that you get at least that education to help you, because all of us need some bits of the law. Today, my guest, Seth Ewuku, candidate in legislative drafting, joins us at the Athabasca University in Canada, joins us to explore this subject. We were also to be joined by Ibrahim Opong Kwating, but unfortunately, he's unable to join us for a very, good reason. Thank you very much, Seth Ewuku, for making time to join us on The Law. I need you to unmute. I can't hear you.
Is that okay now?
Great.
Is that okay now?
Great.
Very well.
Great. Good afternoon and welcome to The Law.
Yes, good afternoon, Samson. I currently am not in Athabasca University. I am in Takoradi, Ghana.
That's right.
Yes.
Okay.
But it's good to see you,
right,
Samson.
Good to have you.
Yes.
And so what we normally have our guests do is to make a brief commentary and give education on the Law 101. And today the Law 101 is Article 19, Clause 2C of the Constitution of Ghana. And it says that a person charged with a criminal offense shall be presumed to be innocent until he is proved or has pleaded guilty. What education will you give our audience about Article 19, Clause 2C?
Yes. I think the essential elements in that constitutional provision is that 1, a person has to be charged. 2, is the element of presumption of innocence. And 3 is the word guilty. Now, first is that when a person is charged of a criminal offense, it is not automatic that the person is guilty.
Right.
Most oftentimes, you will read in the newspapers or something, oh, this person has done this and this person has done that. Oh, he must go to jail. But until a court of competent jurisdiction has pronounced a verdict that he is guilty, he is still presumed to be innocent. That is, a charge in itself is not enough for a person to be presumed guilty. So for the ordinary person walking in the streets of Ghana, they should always be very careful and not to be judgmental, regardless of the gravity or the magnitude of the offense, to jump to the conclusion, however heinous the crime may be, to jump to the conclusion that, oh, he's guilty, or I saw it with my own two eyes, that I was there, yagini, feeling. So it is only the courts, after listening to all the evidence, the witnesses, documentary and otherwise, that the court can reasonably come to a conclusion that this person is guilty or innocent.
And
Right.
As Seth has eloquently, brilliantly explained to all of us, you must note one thing. You may be an accused person at one point or the other, and you would not like anybody to jump to the conclusion that you are guilty even before a court pronounces your guilt. There are circumstances that people have been framed up, or they were just passers-by. They knew absolutely nothing about what happened. Or in fact, the circumstances for which they have been charged, they have a defense, which defense is a good one in law. So, as he said, let's not be in a rush to pronounce people guilty until and unless they themselves have appeared before a court and pleaded that they are guilty, or that they have been taken through the process and have been found to be guilty. And remember, when one is charged with a criminal offense, the burden on the prosecution to discharge is proof beyond all reasonable doubts. There must not be a reasonable doubt. A scintilla of doubt as to the offense will inure to the benefit of the accused person, and they will most probably be exonerated. It is the reason you may have heard it said that we prefer rather for 99 persons who are guilty to be set free than for one person who is innocent to be said to be guilty when they are not. So all of us are entitled to the presumption of innocence once we are charged with a criminal offense. And Seth, in this regard, what will you say to particularly the police and the media when someone is arrested? Sometimes they have not even been charged. Sometimes the person is just a suspect, and you hear how together with the police, the person is projected in the media. What would you say about that?
Well, I think when a person is first and foremost charged, there is a duty on the police authorities or officers to ensure that his privacy, his rights are properly protected, and that information is not disclosed to the public anyhow, because it becomes highly prejudicial. People are watching, society is watching, and the potential for the rights of the accused being prejudiced, or the perception in the court of public opinion shifted against the accused, can detrimentally somehow affect the innocence of the accused. So I think the police must do everything reasonably possible to ensure that they do not prejudice the rights of the accused, or matters are brought in the public domain which are likely to affect his right to a fair trial in our in our democracy. And I think more often than not, there are leakages. There are leakages here and there for purposes of trying to score, especially if the matter is a political case. There's a likelihood of scoring political points here and there, and that, in fact, significantly affects the rights of the accused, affects a fair trial potentially. And so I think the police and the media in particular must be circumspect in this respect, to ensure that we have a fair trial. We have to ensure that the rights of the accused is not abused.
Seth Ewuku.
I can hear you. Yeah.
Yes. We are talking about why community sentencing. Last week, we spent some time on this subject, and it became very obvious that we couldn't conclude it with the discussion last week. We'll try and do a bit of a recap for you, our audience, on the advantages that were spoken about as for non-custodial sentencing or community sentencing, and then we will proceed to now try to find out, that's what we are seeking to do today, try to find out how exactly is community sentencing done, and is Ghana sort of, do the systems that we have allow for exploring community sentencing. So last week, we shared with you what Professor Edward Kofi Koshiga had, presented or spoken about as being the advantages of community sentencing. And we want to show that to you right now. We go over it as a reminder of the list of things that we discussed as being what makes community sentencing good. And then Seth Ewuku, who has experience in Canada, where community sentencing is practiced, to help us to deal with the nitty-gritty, how exactly community sentencing is done. There were people who were asking the question, community sentencing, will it be at the election of the person who has been convicted? How do you police or monitor the person in the community to ensure that they are actually doing the job, the service, community service, which is handed them in place of going to jail? How do you monitor all of that? In a country where our address system is a bit problematic, how do you implement community sentencing? Will it be effective? So these are the aspects that we want to go into. Now, the list we shared with you, that the practice, such as the restorative approach, responds to contemporary social demand and follows current trends in international criminal law. That's non-custodial sentence. Alternative sentencing, or call it community sentencing options, allow the judge to be flexible and to tailor the offense uniquely to the offender and his or her crime. Mild sentencing may be seen as a more effective way of correcting an offender, particularly relating to a first-time or minor offenses. In the case of minor offenses, neither the state nor family nor the criminal concerned benefit from custodial sentencing. I think we all will appreciate that. Non-custodial sentencing promotes social cohesion, integration by allowing offenders to work, communicate with people, and live with their families at the same time. Non-custodial sentencing does not further alienate the offender from the correct social behavior, unlike imprisonment. Non-custodial sentencing increases civic engagement and responsibility on the part of the offender. Once they're working for all of us in the community rather than throw them in jail to sort of rot. Non-custodial sentencing helps to build trust towards a system of social justice. Correctional labor allows offenders to continue using professional skills and has a positive effect on their self-image. Non-custodial sentencing avoids the stigma that attaches to imprisonment. Non-custodial sentencing is comparatively cost-effective. It also does not undermine the income of the offender's family, where he or she is the head of family or sole breadwinner. So this is by way of a recap what we went through for you last week. Let's get Seth Ewuku to try and project to us again for understanding his point of view of what why non-custodial sentencing is important before we get to the basics of it. Yes, Seth, let's hear you. Why is it important?
Yeah, I think community sentencing is very, very, very important. In fact, Samson, I must commend you for this program because it shows the extent to which we are moving and thinking about how to build a better society. Now, I think, first of all, we should look at Ghana's Section 294 of its Criminal Procedure Code. And if you look at the provision there, the language there, it says the following punishment may be inflicted on an offender. Now, it talks about death, imprisonment, detention, liability to police supervisors, etc. Now, if you look at the language there, you can see that the theory, the philosophical foundation of such an approach is that it is retributive. Mm-hmm. That is, it is vengeful, kind of an eye for an eye, a tooth for a tooth, an Old Testament approach to handling offense or crime. Now, I think society needs to move out. Even the Bible has moved away from the Old Testament into the New Testament. And that is where we have to come into what is called a utilitarian theory of philosophy of punishment. And when I think your colleague on your program did an excellent job. I think it's Martin Fabo or whatever.
Yes, we had Martin Fabo last week, yeah.
Yes, exactly. He did an excellent job in showing the two forms of punishment. But I think I want to go a step further in that regard. If you take a utilitarian approach, in fact, a utilitarian approach of the philosophy or theory of utilitarianism emanated in England, somewhere in the 18th century English society. And there was a famous guy by the name of John Stuart Mill, and others like Jeremy Bentham and James Mill, his father, and others, who looked at society and looked at their justice system and asked fundamental question: how do we make offenders or offenders reform? How do we build a better society? And he came up with a theory that in order to do that, we need to achieve the greatest good in a person for the greatest number of people. In simple English, what he meant by that is that we should be a helper to others in society. That is what it is. Now, if you listen to Martin, he went a step further to share that there have been bills, government bills, and AG has been informed, but any time they go to Parliament and they go to cabinet meetings to see how best they can implement or pass these laws, it becomes a problem. Now, that was interesting of what Martin said, in the sense, Samson, in the sense that it tells us that the philosophical foundation of our political actors is still in the, with all due respect, in the Old Testament way of doing things. That is a retributive form of punishment, and not in a utilitarian form of punishment. Are you with me, Samson, on this?
I am.
Yeah, and unless our political leaders and actors clearly understand this utilitarian approach to building a good society, in reforming our citizenry, especially when they offend in society, we will be still in the old school. Now, I mean, my little experience in Canada was that, depending on the gravity of the offense, it is not all offenses that you have to imprison the person as a form of punishment. There are certain essential elements that one has to consider when it comes to community sentencing or non-custodial sentence. One is that we have to consider, will it endanger the community, for example? If an accused person commits a crime, one of the fundamental questions we have to ask, if we are to impose a community sentence, say, for example, go and clean the gutters of Nima or in Takoradi, for example, and we release such a person to the community, will the gravity of the offense that he committed, is he the type of person that will endanger the community? That is a factor that the AG, the Attorney General, I'll come to that, but the authorities would have to be considered. Would they? If, in fact, the conclusion is that, no, this is the kind of person, if we are to release him to go and do community service, he will endanger members of society. No. I remember, I think last week, one of your panelists, you asked that question. And I think the response was that it depends on the circumstance. But I think it has to be very clear that if the person is going to endanger members of society, then he's not the candidate for the type of person. For example, you go and commit murder, and then we allow you to go and do community service. No, that'll be too dangerous for members of society. Or you go and rape a lady. That will be very dangerous for us to release you, to say you have to go and do community service. And I recall that there was a case recently in Takoradi, I think somewhere last year in October. There was a young lady who I think pulled a fast one on the husband or boyfriend of sugar daddy, I'm not too sure, on the grounds that she was pregnant and that she had been kidnapped.
Right.
Now, Samson, with all due respect to my feminist scholars, from time immemorial, women have been playing all kinds of pranks as a way of getting money from men. If they wanted something, they knew how to go along to get a man to get them what they want. But yet, this woman was charged with deceiving a public officer and obstructing justice, and was sentenced for 6 years. Samson, can you believe that? 6 solid years at the Circuit Court in Takoradi. And when I heard that in Canada,
it was said that it was supposed to give a signal and give a deterrence, because it was becoming rampant. People were beginning to, tell lies and deceive that they had been kidnapped when they were not. They had not been kidnapped. And so this was to send a signal to the community that people will refrain from, feigning kidnap.
True. We got to send a signal to society. There's no doubt about it. But for a young woman starting a life, pulling a fast one on a man, this is not the first time. Though here it was an allegation of kidnapping. But this is not the first time women, with all due respect to to women, this is not the first time, and to put a woman behind bars for 6 solid years, respectfully, Mr. Samson, I think it was ganganto. It was excessive and harsh, respectfully. And I would have thought under the circumstance, this was an excellent case. This was an excellent case for community service. I think the interests of society, the interest of the victim, in order to deter her from behaving like that in the future, in order to send a signal to society that you don't do things like that. It would have been better for her to do a community service, for example. Now, but to put her, and I understand there was even an appeal, and luckily for her, she did not, like Martin said yesterday, she was not given another 5 years or 6 years, but she just lost the appeal. You see, so crimes like that is too harsh on members of society.
Right.
And if you recall what you did yesterday, I think you asked, your cameramen went out in society to the public and asked them their views.
Yes.
And I thought that was excellent, Samson, what you did.
Right.
And if you hear everything that people said, Samson, is that you could see that people wanted a community form of service.
Right.
Or sentence.
Yeah. So to the example you have brought, people may say maybe that's even, a crime that drew a lot of attention. People were appalled at the conduct of the woman. Let's look at this other example. I'm going to put something on the screen and then share with you now, so you see if this would have been one other example. This matter happened in the Circuit Court, Dwabing Asante, reading on the 30th of February 2021, and it was between the state and one Senior Francis. Now, the state had brought 2 charges against the person. The first charge was that the person failed to comply with COVID-19 protocols. That is, not wearing the mask. And the person was asked, how did he plead? He pleaded guilty. He was not wearing his mask. And then there was a second count that he had assaulted a public officer in the attempt to sort of arrest him for not wearing a mask. That one, he pleaded not guilty. Now, here are the facts that were brought to the attention of the court. Okay, we have skipped that. If you can go back to the first page. Okay, let me just proceed. So he pleaded guilty, and having pleaded guilty, he was convicted on his own plea. Please go to the next slide. Okay. Then the accused has not wasted the court's time. This is the mitigation. The accused has not wasted the court's time, and I pray that the accused is giving a minimum sentence. Prosecution states that the accused is not known. And when we say the accused is not known, it means it's a first-time offender. And this is the sentence. Having pleaded guilty to the offense, the accused is hereby sentenced to pay a fine of 200 penalty units, or in default, 3 years imprisonment. My sentencing is based on the fact that there have been countless reminders for persons to put on masks in order to prevent the spread of COVID-19. This sentence will serve as a deterrent to persons who refuse to wear the mask. The accused is granted bail on count 2, and for disclosure to be served on the accused in order for CMC to proceed. So this was the judgment, and eventually this is what happened. The second count, the prosecution did not press the second count. So the accused, having been sentenced to 2,000 penalty units, or in default of paying the 2,000 penalty unit, was to go to jail for was it 200 penalty units? Yeah, 2,000 penalty units. Yes. Now, 12 times 2,000, that gives you 24,000 cedis. So he was to pay 24,000 cedis, and if he was not able to pay the 24,000 cedis, he was to go to jail for 3 years for not wearing his mask. He was unable to pay the 24,000 cedis. So in the circumstances, he's supposed to be in jail as we speak for 3 years.
Well, as much as COVID is a very serious matter for society, and we are all concerned that we do the right things, and I think the government has played a significant role in warning members of society about safety protocols or COVID protocols. However, some members of society refused to follow due process, notwithstanding, Samson, that 3 years for not wearing a face mask. 3 years. Now, I think we should also bear in mind our prison systems.
Yeah.
And how they look. Whether or not, in fact, the overcrowdedness there, when one returns, the person becomes a hardened criminal. The cost of maintaining such a person in our prisons. I mean, I don't know. I'm sure the Minister for Interior would have a hard time, or is having probably a hard time, making sure that people in prisons are properly fed, or are having their nutritious meal. I don't think so. Regardless of whether or not they are convicted, they are still human beings, and they are entitled to their human rights. So I have difficulty, Samson, that in spite of our inability to reform people in our prisons, to provide them with the proper care, the cost of maintaining them, in spite of all these challenges, we are still putting people who just do not wear a face mask, we give them 3 solid years behind in Sawam.
In fact, Seth,
in
fact, I don't know what happened in this situation for the minimum of 3 years sentence that was given. Otherwise, according to the Imposition of Restrictions Act, the minimum is 4 years. The minimum is 4 years, and the maximum is 10 years.
Yes.
Yes.
So the judge was even lenient
under
the circumstance.
Exactly. And in fact, an appeal may bring out the fact that the judge didn't have power to give the accused 3 years, because the power the judge had was to give the accused a minimum of 4 years. So from 4 years to 10 years, that's what the judge could do. And for the fine, 24,000 cedis was what he was supposed to pay, and I think the maximum is about 60,000 cedis.
Yes.
The Ghana Bar Association issued a statement asking that it was too harsh, the law needed to be worked on. Nothing was done, really.
Yeah. At best, what the Ghana Bar can do is to protest. But it really lies in the hands of cabinet or in a government bill. They need to they need to have the right philosophy for society. You see, we can pass bills, we can write, we can draft bills and all that for Parliament and all that. But if we don't believe in what we are drafting for society, then it won't go anywhere. We must believe that we are reforming society. It must be a philosophy of society. Sometimes we always talk about law, but we don't talk about the philosophy underlining the law. And I think that is what is important. And that is why I raised earlier on, because if you look at 18th century England, they were having this kind of discussions that you and I are having today, or you are doing for society today, Samson. They were asking, how do we help people to reform? And there's a famous book by John Stuart Mills on liberty, and he talks about the greatest good for the greatest number of people. And I think it is that philosophy that influenced community sentencing principles. You see, and unless we believe in that, unless we appreciate that it is not only law that is the basis of everything as a society, but that the philosophy, the belief in a particular philosophy, to help our audience to, perhaps I may go biblical and explain that well. Now, Samson, you will agree with me that in the Old Testament has now been replaced by the New Testament. Are you with me?
Yes, an eye for an eye.
An eye for an eye. And they were very, if you look at some of the stories in the Old Testament, and even you ask yourself, if you ask questions about how judgment, I mean, for example, the story, for example, of Adam and Eve. Now, if you look at the story of Adam and Eve and why and how God punished Adam forever and ever, and not only that, punished every descendant of Adam, just because he had eaten the fruit. Now, how proportional is such an offense, punishment to the offense? It was overly gangan, Samson. Just because he ate.
So, for the purposes of time, let's now go into how this actually works. And you have sort of taken our attention to our orientation as a nation. Our parliamentarians go to parliament and they make a law and they say, if you don't wear a mask, you should go to jail minimum 4 years, maximum 10 years for not wearing a mask.
Yes.
When they could have thought about community service. But because we don't have a law on community service, you would say that that could also be the reason they don't think about it. And the law says, if you are found guilty for not wearing your mask, the minimum fine you should pay is 1,000 penalty units. That's 12,000 cedis. And a judge decides that instead of giving you 12,000, I'll give you 24,000. And knowing that the person may not be able to pay, and if they are not able to pay, then they will go to jail.
Yes.
So this is where we find ourselves. Now, the orientation that you have spoken about now, and then from last week as we discussed, the good thing to look at is community sentencing. How is community sentencing done from your experience in Canada?
Yes. Communities, when, for example, as you earlier on observed, if the offense is a minor one, for example, and that it is not one that will endanger the community, and it is not an offense, for example, involving drugs or trafficking of drugs or importation of it, and there's no such thing as no weapon, or the accused has not been in breach of any prison term in the past, or it's one that is involved in a sexual assault, or it is one that is involved in kidnapping or arson or anything of those things, then because first of all, when the police officers gather their do their investigation, they send it to the AG's, the Attorney General's department. Then the Attorney General's department will look at it. The case will be called on a particular date, and before that, the charge sheet, the witness statements, the will say statements, everything will be given to the accused person. The accused person will go to, let's say, if he doesn't have money, will go to legal aid or go and look for a lawyer of his choice. And suppose he came to me, for example, and I looked at the facts and I speak with him, and my sense is that he has a defense. But hey, he says that, look, he did it. Now, when the case is called, when we go to court, and he says, okay, well, he wants to plead guilty, fine. Then at that point, I want to talk to the AG. Now, the AG has a program. The AG's office, the Attorney General's department, they have a program. Say, for example, it is one about domestic assault, let's say. And the accused, in fact, according to the statement, the written statement, witness statement, picture, photographs and everything, there's evidence that, in fact, a spouse has been assaulted and the husband is accused. You get all these reports. The AG gets have a copy. I get to have a copy. Now, on the first day of trial, the judge will say, give us an opportunity to speak with the AG and see what kind of plea bargaining that can be done.
Okay.
At that point, we may suggest community service now, or community sentencing. Now, at that particular, it's not everybody who is comfortable in doing community sentencing.
That's right.
Or community service. If I remember last week, I think one of your panelists, one of your
the callers.
Yes, so exactly. Raised this point that he would rather prefer to do a jail term
quietly,
rather do a community service.
Right.
Now, so the starting point is that the accused person must be willing to do the community. He must volunteer or accept responsibility for the offense that he has committed. That's the first thing. And number two, he must fully and freely consent to participate in a community sentence. And number 3, he must be supervised. I remember last time, this was one of the issues one of your panelists addressed. I was not too sure of. Now, you don't send somebody to the community just for the sake of sending him. He has to be supervised in the community.
Yeah. Esther spoke about, gave the example of, I think in Kenya, where a lady went through community sentencing or service and was sent to a hospital, and then she worked in the hospital as her sentence. By the time she was due to leave, she got a job and just stayed to work there.
Beautiful. Beautiful. Now, say it was an issue of assault, for example. The AG may have a program like a counseling program. Because sometimes when you, it's not enough for the person to be on probation, be of good behavior and that kind of stuff. They must also undergo a professional counseling program for a period of about 6 months. And I've had a situation where my client had to go through that. And then once they complete the program, Samson, they have to obtain a certificate from the counselor, from the psychologist, a professional, not a pastor, a professional psychologist, that he has attended a counseling program, that he has understood the impact and consequences of assault, that now, if given an opportunity, he will be of whatever, he will be a good person. And then he would have to come to court with his lawyer, with the letter, and show to the judge that in fact he has undergone a program of rehabilitation or of counseling.
All right.
And that the judge is now satisfied that he can release him.
All right. I'll get back to you again to tell us some of the forms. You have just told us one of the forms that the community sentence will be submitting yourself to counseling. What is it? How is that punishment? I have done something and you say I'm assaulted, then you let me go through counseling and I am certified that I know that it's not good to assault people, and then you let me go free. What kind of punishment is this? That's what some people don't understand. All right,
that is the beauty of that is the beauty of Canadian society.
Right. This discussion is facilitated.
Canadian society.
Right. This discussion is facilitated by the Commonwealth Human Rights Initiative, and it's part of the USAID Justice Sector Support activity. The activity is being implemented by 4 organizations: Legal Resources Center, Commonwealth Human Rights Initiative Africa Office, Crime Check Foundation, and Interregional Bridge Group, with funding support from the USAID. You can call us now and let's hear your contributions and questions once again on community sentencing. Thank you very much. So whilst we wait for your call, Seth Ewuku will continue to help us with the forms of community sentencing that are available. He's giving us one, which I suppose from our orientation in Africa and in Ghana, many of you may say, this one, how? You've committed an offense, then we rather give you psychological support and let you go through a process, and then after that we certify that you have understood the gravity of what you do, the consequences, and you will not do that anymore, and then end of the matter. Yes. So, Seth.
Yeah. In addition, the counseling, of course, will be in addition to other factors,
okay.
other punishments.
All right.
But Samson, the beauty of it is that, you see, it's the approach or the philosophy of society. We want to help people to reform,
the humanity,
to become a better Say it again.
I said the humanity or the humanness attached to it.
Exactly. And with all due respect, this is what some advanced societies or societies like Canada, more sophisticated, try as much as possible to build the human individual, to make him or her a better person.
Right.
Because this is what I think Martin was sharing with us on your program the other time, that the utilitarian approach, that is helping people to become better. Because once we help people to
instead of the retributive approach. Let me pick a call from Tijani. Tijani, you are calling us from Koforidua. Let's hear you.
Good afternoon. I'm actually very, very much happy that this is going on. And this is more or less like an appreciation of the discussion. I must say, I'm really in love with community sentences. Listening to the man, I feel that is even more punitive than going to the prison. Because if I'm going to go through counseling, remember, not everybody is able to sit and listen. Some people, someone who is able to assault the lady doesn't have the patience to go through counseling. But if the person has stepped to go through this term of counseling, 6 months, not easy. I think this person will come out to be more reformed than going to the prison. The prison is going to make you more hardcore. Coming back, you know the situation there. You might even do worse than what you did before you were in there. So, Samson, I beg, if this advocacy can go to the higher bodies, let's have this established more than what we term as punitive by sending people to prison. Okay. I'm very much grateful.
Thank you, Tijani. And Tijani just called to say thank you to Seth Ewuku for the education that he's giving. And remember that he isolated the crimes or the offenses for which you may be considered for community sentencing. It's not everything. It doesn't include murder, drug offenses, sexual like rape and the rest of them. Okay, let's please go on, Seth. We are talking about the forms of community sentencing.
Yes, and then we have the rehabilitative. I will just use the example, the Kenyan example you just talked about. Look at the beauty of it. Here is a person who has been posted to a hospital in Kenya. Now, while she's doing her community service, she gets hired in the process. I mean, that is so reformative. And that is what our criminal justice system must attempt to do. The philosophy of the state must create better people, better individuals in a society. Because the more our people are good, the better it is for the society at large. It's for the greater good of us all.
That's right.
But so I want to, the Kenyan example, I think, is an excellent one. And if we can take a cue in terms of how an individual who has committed a crime, society decides that, look, we will punish you, but we would like to reform you or rehab you in a hospital. She goes. As the process of working there, she learns her lessons and decides, can't I have a better life? I am sure probably she was also having some counseling in addition. And all in all, at the end of it, Samson, she gets hired.
Right.
The state of Kenya has succeeded in making a better human being who is now going to produce for the greater good of society. Right. Because every life she saves,
I need to take this other call from Theophilos. Theophilos, you're calling us from Bupe. Unfortunately, looking at the time, I may not be able to take any more calls. Yeah. Hello, Theophilos. Did I lose Theophilos? Okay, I think I lost Theophilos. I was going to say you can try again, but I'm sorry, time just ran out. We have the Planting for Food and Jobs. We have several other programs that are ongoing that people will be willing to help to do work there as their punishment Recently, we have seen people in certain communities that people do wrong, they decide to arrest them by themselves and ask them to clean up a gutter. And then they feed them in addition and advise them to go and sin no more. Even though some of those things are illegal, it does appear this is what a section of society is beginning to appreciate, that is a better way of punishment for minor offenses rather than custodial sentencing. So in the next 2 minutes, how will you round up?
Well, for me?
Yes. Unfortunately, says connection is getting bad. It's getting really bad, but time is just run out. So this discussion is facilitated by the Commonwealth Human Rights Initiative, and it is part of the U.S. Aid Justice Sector Support activity. Yes, Seth, we can hear you now. I think your line is normal now.
All that to build a better society, and in particular with the criminal justice system. I just want to comment or make a note.
Oh, too bad. Like I said, the discussion is facilitated by the Commonwealth Human Rights Initiative, and it's part of the USAID Justice Sector Support activity, which is being implemented by 4 organizations: Legal Resources Center, Commonwealth Human Rights Initiative, Africa Office, Crime Check Foundation, and Interregional Bridge Group, with funding support from the USAID. And this afternoon, my guest has been Seth Ewuku, candidate in legislative drafting at Athabasca University, Canada. He's a lawyer, obviously. We were to also, as we had advertised, Ibrahim Opon-Kwarteng, Executive Director, Crime Check Foundation, Ambassador Extraordinaire of the Ghana Prison Service, was to join us, but unfortunately, very unfortunately, he's unable to do so. This has been the law. It is your legal light. It is your help law. Will come your way next week, God willing. We hopefully would have the Attorney Generals and also one other expert try to give us a conclusion by looking at a process or processes that the country has begun in trying to introduce community sentencing. Where are we with it? What should be done to ensure that we have it as quickly as possible, and in what form should it be? I'm Samson Lardy Anyenini. Have a good afternoon.